Taylor Swift's trademark application for The Life of a Showgirl just got suspended. Let's talk about it. I'm Camelia. I'm a trademark attorney here at Imani Law, and I want to go over why this is important for you as a business owner to know and what you can do to avoid this. So Taylor Swift's attorneys filed for The Life of a Showgirl. The US Trademark Office came back and said, hey, you can't have this trademark because there's already a registered mark in the trademark database, and that brand is called Confessions of a Showgirl. I know what you're thinking. Those two marks do not sound the same at all. But that's why I wanted to make this video, because at the end of the day, it doesn't matter what you think. It doesn't matter what I think. It doesn't matter that Taylor Swift is a billionaire and arguably one of the most famous people in the world right now. At the end of the day, the trademark standard for registering your brand is the same. The trademark officers at the US Patent and Trademark Office, the US PTO, their standard is likelihood of confusion. The trademark examiner that was assigned to this application said, hey, look, the use of the word showgirl is confusing enough. Again, we automatically know that it's related to Taylor Swift. It does not matter, and that is the whole point. At the end of the day, Taylor Swift is not above trademark law. It happens all the time because clients will come to us and say, look, I searched a trademark database. There's nobody that has a similar brand name to me. And what we'll do is a knockout search. We'll tell the client, hey, actually, there are these other couple marks that are going to be problematic for your trademark application if we were to move forward and file. Because a regular business owner, unlike Taylor Swift, isn't a billionaire. They don't want to spend tens and thousands of dollars to fight an application. Taylor Swift, who's a billionaire, spending $20,000, $30,000, $40,000 to defend a trademark application is not a big deal. But when we work with the average business owner, what we want is to tell you before we even file your trademark application, what the chances are of your brand even getting registered. So we can tell you before we file whether your brand is a high risk, a low risk, or a moderate risk, and what our arguments would be if you were to get a similar refusal. Because a trademark attorney who's been doing this for so long like us, we know what to look for. We know what the trademark examiners on the other side are going to flag, so that you're not in a position 6 to 9 months down the road where you're like, oh my God, I wish I knew this beforehand. If I knew this was going to be an issue, I would not have filed. I would not have wasted my money. I wouldn't have spent this time and energy. I would have rebranded from the beginning. So the takeaway from this video is that, one, this is preventable. If you have a comprehensive search done from the beginning, you can prevent this from happening because you can rebrand, or you can work with an attorney who can tell you what the chances are of you getting registered. Two, the standard of getting a registered trademark is high. If you don't think a brand name is similar to yours, it doesn't matter. At the end of the day, what matters is if the trademark examiners on the other side are going to think that and they have a specific standard. And three, nobody, even Taylor Swift, is above trademark law.